with the award comes a few things. First of all, comes a $1,000 check, which I gotta say, this Mary drafted. Mary had done like 5 months ago, so you only have a month before it runs out. So there's that. And then along with it comes this plaque. And the plaque says, Villanova University, the Praxis Award in Professional Ethics, Louis S. Rulli, in recognition of his commitment to professional integrity, presented the 16th day of April 2015, the Ethics Program, College of Liberal Arts and Sciences. Congratulations. Thank you so much. I'm deeply moved by those wonderful remarks. First, to Villanova, I am deeply humbled by being selected for this award. And I commend you for your commitment and your dedication to ethics in all professions to make our society and our world a much better place. Thank you. To my colleagues who surprised me here to speak, to Kathy and to Vera, you know, my students often ask, what do you look for when you graduate? And I said, I like to say, the most important thing to look for is to look for a place that has colleagues who you respect, who share your values, who you could see yourself day by day working alongside and sharing. And I can't think of two more wonderful colleagues who have been such partners for so long. Thank you both for being here today. Speaking. Now, how do I live up to all this hype here? I'm worried, you know? I don't usually get a little nervous, but I'm getting a little nervous here listening to all of this. So I'm truly honored, though. And, you know, I received a call from Dr. Rulli, and he informed me that I had been selected for this award. And I have to admit, I'm going to be honest here, I had never heard of the Praxis Award. So, now, I do know that fans of Star Trek, and my wife is a big fan of Star Trek, recognize that Praxis was a moon that orbited the Klingon home, right? And it was destroyed in Star Trek Into Darkness, and I think in Star Trek 6 as well. So I was wondering, what was Dr. Rulli trying to tell me, you know, about my body of work? Were my writings, teaching, and advocacy so far out there that they deserved a similar fate? But I've come to learn that's not what he had in mind, and I really do think it's so important to embrace the concept of praxis. And it may mean different things to different folks, but for me at least, it does mean the real practical application of theory, to really examine the gap between theory and practice, and to connect our ethical underpinnings of all of our professions and our work to the well-being of the communities in which we live and serve and the world as a whole. And I am especially grateful to be here today to speak with you. Now, they told me that I had to give a half-hour lecture, so those of you who are hungry, I apologize. Those of you who have to leave, I understand, but I have to live up to my ethical obligation to give you a half-hour lecture. So I'm going to talk about a topic that you may have already guessed, and that's justice. I don't think there's a more important topic. You know, a Carnegie Foundation report that studied medical and teacher education posited that there are 6 major dimensions along which professionals must function, regardless of their specialty. Professionals employ fundamental knowledge and skills derived from an academic base. They make decisions under conditions of uncertainty. They engage in complex practice. They learn from experience. They create and participate in responsible professional communities, and they have the ability and willingness to provide public service. It is that sixth dimension that I want to speak with you about tonight. The ability and the willingness to provide public service, particularly as professionals in the law. It is certainly a timely subject. The New York Times editorial in 2011 reported that American legal education is in crisis. The economic downturn has left many recent law graduates saddled with crushing student loans and bleak job prospects. Yet, at the same time, more and more Americans find they cannot afford any legal help. The New York Times called for changes to legal education, and perhaps most importantly, how the legal profession sees its responsibility to serve the public interest. This is so important. The fundamental values of our democracy are expressed in the inspiring words of our Declaration of Independence and in the legal framework of our Constitution. Our founders not only declared independence, but also built a national government sufficiently strong and flexible to meet the needs of the Republic, but yet sufficiently limited and just to protect the guaranteed rights of citizens. In 1892, our fundamental values were actually expressed in the creation of the Pledge of Allegiance. It was created by Francis Bellamy, a Baptist minister, who published a children's magazine. It was his intent to instill in the minds of American youth a love for country and the principles upon which it was founded. The United States Congress recognized this pledge for the first time on June 22, 1942. And the text of the Pledge of Allegiance has been amended 4 times since its original creation, adding most recently the phrase "under God" in the most recent revision in 1954. The final 6 words of the pledge, however, have not changed at all since its creation more than 120 years ago. In 1892 and today, our Pledge of Allegiance ends by expressing perhaps the most enduring values of our democracy, with liberty and justice for all. It is that promise of justice that I will speak about today. For most of its history, the United States Supreme Court did not have a permanent home. It met in Philadelphia, it met in Washington, and a variety of places. But on October 13, 1932, Chief Justice Charles F. Hughes laid the cornerstone of the Supreme Court's permanent home in Washington, D.C., at which he said, "The Republic endures, and this is the symbol of our faith." The building was constructed in classical Corinthian architectural style and on the same scale as other government buildings, representing that they were a co-equal branch of government. But inscribed above the 16 marble columns on the main west entrance to the court are the words, "Equal justice under law." These words express the promise that as the final arbiter of law, the Supreme Court is entrusted with ensuring to the American people the equal justice of the law. This overarching value is also expressed in the judicial oath to which all federal judges are sworn. Under that oath, judges promise to administer justice without respect to persons and to do equal right to the poor and to the rich. This is the essence of equal justice. But is it our actual experience? Or is it, as Stanford law professor Deborah Rulli has argued, that the promise of equal justice under law is a rhetorical flourish commonly encountered in ceremonial rhetoric that comes nowhere close to describe the equal justice system in practice? Or, stated differently, is it, as the award-winning, inspiring song "Glory" from the motion picture Selma by Common and John Legend suggests, justice for all just ain't specific enough? Professor Rulli goes a step further. It's a shameful irony that the nation with the most lawyers, has among the least adequate systems for legal services. It is more shameful still that the inequities attract so little concern. So what we've learned over the past several decades is that the legal needs of the poor are substantial and unmet. The New York Times editorial put it this way: most low-income Americans cannot afford a lawyer to defend their legal interests, no matter how urgent the issue. Sustained cuts in federal funding, reductions in legal aid staffing, and a recession has swelled the ranks of the poor, all contributing to pushing access to legal help beyond reach for too many Americans. Legal needs studies in Pennsylvania have found generally that only 1 in 5 low-income people who experience a legal problem are able to get help from any source. And even more troubling, the poor who seek legal help represent only a fraction of those who really need legal assistance. It's not hard to understand why. When the Legal Services Corporation was started in 1974, signed by President Nixon into law, 12% of the population was financially eligible for free legal help. Today, due to soaring poverty levels, maybe 21% of Americans are now eligible. Yet federal funding for civil legal aid has dropped substantially in the last 20 years. Poverty has reached some of its highest levels in 50 years. Today, Philadelphia, for example, has the unfortunate recognition of being having the highest poverty rate of any of the 10 largest cities in the nation. And the problem is only growing worse. So why is it important that the poor have access to legal representation? As a young legal aid attorney, and there was a time when I was a young legal aid attorney, last week Kathy Carr in the office, more than 30 years ago, I learned the answer to that question. Hester was a 56-year-old woman with marginal education who had been employed as a domestic worker most of her life. And she came into my office for the first time. She suffered from a long history of chronic pancreatitis, chronic arthritis, recurring ulcer, and irritable bowel syndrome. In other words, she was having a great deal of trouble eating. She was often vomiting, she was gagging, she had incapacitating diarrhea, and disabling stomach pain and swelling. This was confirmed in the medical records, and it was apparent to me as she barely had the strength to walk into the office. Her weight was down to 88 pounds. But believe it or not, she had just been thrown off the disability rolls of Social Security, the agency having found that her condition had improved sufficiently to enable her to engage in substantial gainful employment. Social Security benefits were her only income, and the only thing standing between her and welfare, between some notion of dignity and despair. She was frightened, and I still remember her asking me over and over again, how can they say I can work? Why won't they believe me? Why won't they believe my doctors? At that point, the Social Security decision was a final decision, and I filed a complaint in the United States District Court, asking the federal court to review and reverse the agency's decision. You see, it was the early 1980s, and federal courts were becoming increasingly aware that the administration was literally throwing hundreds of thousands of disabled recipients off the rolls, a shameful display of indifference to some of our most vulnerable citizens. The case was assigned to the late Chief Judge Joseph Rulli, one of the finest federal judges in the country. And he reversed the government's decision, writing the following words in his letter. This case presents an appalling example of sheer bureaucratic dishonesty. The evidence shows overwhelmingly that the claimant is totally disabled, and for the administrative law judge to hold otherwise is an indulgence in the most blatant hypocrisy. If the purpose of the United States Department of Health and Human Services is to crush defenseless human beings, as it seems to be, it would succeed unless in cases like this, courts interpose a protective law. Now you might think this is the end of the story, but it was not. My client called to say she still hadn't received her benefits. I called the government's lawyer. Days turned into weeks. Still no money, no benefits. I filed a contempt motion against the United States, seeking attorney fees to try to get some leverage. Still no money from my client. And then I learned the power of the Fourth Estate. Newsweek called up after reading the judge's order and asked if they could interview my client. I arranged for that. She was soon featured in an article in the weekly magazine on the crisis of Social Security. The very next day, after the magazine hit the stands, I received a call from the government's lawyer. They were Federal Expressing the client's check to her. Now, it shouldn't take a lawyer, a federal court, and a national magazine to get Social Security benefits to a person who is so clearly entitled. But let's be honest. What would have happened if there wasn't a lawyer for this 56-year-old woman? And how many like her ever got the benefits they richly deserve and needed, along with the dignity that comes with it? Because justice for all, too often, means justice for only some, those who can afford it. The growing inequality of wealth in this country presents a special danger and threat to our civil justice system. The rich being further separated from the poor, and the poor forgotten. It is driving in our democracy, legislation, and public policy toward special treatment of those who need it least, and away from the social and educational needs of those who need it most. The stark inequality really poses a special threat to our justice system, where their access is diminished beyond reach. The legal profession has a special ethical obligation and responsibility for the quality of justice. We memorialize that in our rules of professional conduct, but we must ask ourselves, is the profession living up to this challenge? There are reasons to be unsure. In Pennsylvania alone, we watch in distress as example after example of ethical disgrace occurs. From Kids for Cash in Missouri County, to the sharing of racist emails among our highest judicial officials, to political corruption touching our highest courts, to culture of fixing tickets, our judges in traffic court, the exchange of favors between judges and the administration of justice, and allegations of intentional grand jury abuse for political purpose, the list goes on. It is in the face of such greed and corruption and dishonesty that we must honor the decent and committed and caring folks, lawyers for the poor, who forego the wealth and the perks of the profession for the serious challenges of making justice accessible to everyone. I know that some of you here tonight, and I applaud all of you for what you do for us. I have, in typical fashion, not a half hour lunch. There could be an hour lunch, so I'm going to skip over a couple of things. And I'm happy to talk with you. But I do want to say a few things about the challenge for the future. It is time to recognize that the funding mechanism for civil justice functions exactly the opposite of how it should. Resources for legal help to the poor evaporate just when they need it the most. In times of low budgets, budget woes that we face, as the need of the population grows for legal help, what happens? Funding for legal aid drops. And that's true not only in federal funding, but other programs like Pennsylvania I hope which is the second largest funding source for legal aid. So when the poor need their lawyers the most, the funding streams that make it possible go down, leaving a serious justice gap in So providing free legal assistance to the poor, though, is not only the ethical thing to do, it makes good economic sense. Until recently, we've really not studied the economic impact to state and local governments from such work. Recent economic impact studies, however, point to highly favorable economic returns to local communities from each dollar spent on legal aid. A Pennsylvania study, for example, in 2011 found that for every dollar spent on civil legal aid to the poor, that investment returned more than $11 in direct economic benefits to local communities. More research is needed on this question for sure, but legal aid is a sound investment in boosting the economic health of our local communities. So what is the legal profession doing in support of our civil justice system? First, we all must support full funding for legal services. We must aspire to the gold standard of full representation for as many indigent families as we possibly can. Full representation is what corporations and wealthy individuals expect. They deserve it. They receive it when their vital interests are threatened. And our constitutional guarantees demand no less for those who don't have the financial resources to acquire. Second, we must work toward a right to counsel in the most serious of civil matters. In 2006, the American Bar Association called on federal and state jurisdictions to provide counsel as a matter of right, what we call sometimes civil bidding, in respect to the Gideon versus Wainwright decision of the Supreme Court. Called on us a right to counsel at public expense for low-income persons in adversarial proceedings involving basic human needs like shelter and sustenance and safety and health and child custody. Since 2006, there's been a resurgence in a movement to bring right to counsel. Third, the Conference of Chief Justices has called upon states to establish blue ribbon access to justice commissions to bring together stakeholders to study the problems of access to justice for the poor and to formulate real mean solutions. Today, 31 states have such blue ribbon commissions. 9 others are actively considering it. Pennsylvania does not. We should. Fourth, we must get serious about pro bono representation from all lawyers. Ethical rules require lawyers to perform pro bono legal assistance, and in large measure, legal aid programs have worked very closely with bar associations, with law firms, nonprofits, and with law schools to build innovative pro bono initiatives that deliver high-quality representation to the poor. All lawyers can do well by doing good, but it's particularly important now as business-driven decisions increasingly dominate our legal practice. Pro bono legal assistance keeps the profession centered on core values like justice, like the fair administration of justice, which the Conference of Chief Justices calls the cornerstone of our democracy. I'm going to skip a few more pages. But you get, I think, the sense of the message that I'm trying to deliver. There's so much work to be done. And we all have to be part of the solution. And there was a wonderful article, and I was going to summarize it for you, but I'm not going to do that. In the Sunday Times magazine recently about the detention camps in the United States. And I hope some of you saw that. And you saw the role that pro bono lawyers can play in helping to protect the safety of women and children who flee the extreme violence, particularly in Central America, and come to the United States with the hope that our founders came to this country. And they sit and they wait for deportation hearings before judges, and without legal counsel, almost all of them return to the violence, which is even more severe having fled when they're targeted children are killed when they're returned to Honduras and to Guatemala. That goes on in the name of the United States of America, and we all have something to do about that. So I'm sorry I'm not going to give you a full story on that, but you can read that in Sunday Times Magazine. What I would like to do is say that ultimately I'm going to look to the future. I'm always an optimist, those who know me. And ultimately these challenges lie in the hands of the next generation of lawyers. So I want to talk to the students. And we had a wonderful lunch earlier today with so many students. And they are really the inspiration. And it's why clinical legal education and pro bono requirements in our law schools and our universities are so important. They help law students develop lawyering skills for sure. But more importantly, they expose every law student to segments of our population for whom the laws promise for sure. They learn firsthand the ethical dimensions of what it means to be a lawyer. And we're going to talk a little bit about civil forfeiture. And so I want to share with you a story. The Penn Legal Clinic had been working especially hard in the area of civil forfeiture. And as she explained to me, a person can lose their home even though they are never convicted or even charged with a crime. It's a very harsh law. And it was intended to go after large cartels and drug traffickers, but it's been unleashed against ordinary citizens in our communities with devastating results. But it's also a complex area of the law that really is beyond, that ability of anyone to handle it on their own. And not long ago, a husband and wife living in North Philadelphia, I'm going to call them Mary and Leon because they've given us permission to use their names. They came to the clinic after being served with a petition by the district attorney's office seeking to forfeit their home for 3 alleged $20 marijuana sales by their adult son, one of which allegedly occurred on the porch of their home. Mary and Leon were 68 and 70 years of age. They were solid citizens. They had never been involved with the law in their whole lives. They were never charged with a crime or convicted of a crime. Leon was a former steel plant worker. Mary was a retail saleswoman and a former block captain in her community. Their home was all paid up, and they now lived on very modest means, financially qualifying for food and services. And they were frightened. Frightened about the prospect of losing their home at their age with nowhere to go. Frightened for their adult son, who was now facing criminal charges for a drug offense, and how they were going to help him through that crisis in his life. Frightened because Leon was battling pancreatic cancer at the same time, and they needed to spend a lot of time in the hospital and with doctors. They didn't know what to do, and they didn't understand why their home was being taken by the state when they hadn't done anything wrong. Their story was featured in the New Yorker magazine, lead article taken with their permission. And at first, they didn't want their identities disclosed. But finally, they decided they would do so if it could help someone else. That's the kind of folks that they want. Folks that you like instantly. Folks who would never hurt anyone else, who cared about their neighbors. And if ever an elderly couple needed legal help, it was Mary and Leon. Pitted against the power of the state, too poor to afford a lawyer, worried about their son, frightened that they would lose their home, involved in a legal battle that was complex. The situation really defines how important the concept of equal justice really is. For certainly, if you were in that situation and you had money, you'd hire a lawyer to balance the scales of justice, to protect the most important possession, perhaps, of your life, your family home. Indeed, who needs to have to battle this battle when you're also battling health and serious challenges of age? And so the question is, how can we promise equal justice under law caught if we're unwilling to promise a lawyer for Mary and Leon. This is why adequate funding is so important. This is why right to counsel is what is the next major challenge of our civil justice system. Now, Mary and Leon's story has a good ending. With the help of bright and dedicated law students in the clinic, and one of my colleagues, Susanna Greenberg, who's here from Penn Law School, we presented statutory and constitutional defenses to the action. Mary and Leon saved their home and could turn to the other challenges in their life. But for so many others, they weren't so lucky. And every day, most civil matters, low-income Americans have to fend for themselves. I've been very fortunate in my life. I've had the wonderful support and the love of my family here, my lovely wife, my partner Carol, my son Steve, my daughter Annie. I'm so proud of all of them. I lost my mom just a few months ago at age 95. I know she would have liked to have been here. She really, along with my father, defined what it meant coming from the greatest generation. We have a great responsibility to future generations. And I've had the love and support of my colleagues. You heard from two today, and you can see that I've been blessed. And I want to thank all of you who came today. You are all very special, and this award is very special. So I'm going to close now. I'm going to close with a scene from a Hollywood movie. My colleagues at the clinic, I see Rachel there, when she smiles, she knows what's coming. My colleagues at the clinic know that I love to bring film into the classroom to demonstrate important points. A few weeks ago, actually Susanna was teaching this class, it was a class on direct examination. And there's a great scene from a movie, Philadelphia, one of my favorite movies, which nicely demonstrates how in direct examination the lawyer should fade into the background, and it's the time for the witness, the client, to take center stage and tell the story. And as you probably know, the film Philadelphia tells the story of Andrew Beckett, played by Tom Hanks, a senior associate and star at the largest corporate law firm in Philadelphia. Beckett is gay and is an AIDS patient, hiding both from the partners of his film. As lesions appear on his face, the short telltale sign of carpocity-sarcoma, a form of cancer associated with AIDS, he takes time off for a few days to hide those lesions. And he's assigned the responsibility of preparing a legal document in the firm's most important case. He does that from home. He brings it to the firm and leaves it with an assistant to get it filed. The deadline is upon them, and the firm can't find the paperwork. They're frantically looking for it. They don't know where it is as the deadline inches closer and closer. Finally, the paperwork is found and filed at the last possible moment. Beckett is fired by his partners, and he believes that his work was intentionally sabotaged to give the firm an excuse to fire him because of his AIDS diagnosis. Beckett tries to find a lawyer to represent him, can't find him. No one will take his case. He begins to represent himself. But finally, he gets a lawyer. Joe Miller, played by Denzel Washington, who agrees to take the case after he turned it down because he saw how folks around Beckett shunned him because of his disease. So Miller takes the case, and we now are in that court scene with Beckett on the stand, being questioned by his lawyer, Denzel Washington. And we show this scene in class to help the students understand an effective direct examination. but it holds much greater meaning for all of us. Miller asks Beckett whether he is a good lawyer. And when Beckett says yes, Miller asks him why. Beckett responds that he loves the law. And Miller then asks the question, what do you love about the law? It is Beckett's response that is so illustrative for us. And I will share it with you. But admittedly, without the music in the background, and the drama of Courtroom 243 in Philadelphia City Hall, where the film was actually filmed. I can't replicate that. Miller asks the question, Andrew, what do you love about the law? Beckett responds, many things. What I love most about the law, every now and again, not often, but occasionally, you get to be part of justice being done. It is really quite a thrill when that happens. Ladies and gentlemen, it really is a thrill to see justice being done. And we have a collective responsibility to see that it's done. Not occasionally, but each and every day for all of our citizens, rich and poor, black and white, young and old, and with your help, if we work together across all of our professions, and most important, if we just collectively care, our justice system will earn those